Hello, everyone. This is Bill Oldak from the Voorhees, Washington, D.C. office, and I have with me my colleague Aaron Williams from our Cleveland office. And today we are pleased to be presenting to you our 2021 IP law preview on cases and issues to watch. And hopefully there is folks. Thought I was supposed to have a screen up here that was going to be giving me, oh, it was hidden behind this other thing. There we are. Here we are. Sorry about that. Yeah, I'm Bill Oldak, and Aaron Williams is with me. And first, I'm going to toss it to Aaron, who is going to give you kind of a preview on what we're going to be discussing today.
Good afternoon, everyone. Thanks for joining us. Like Bill said, my name is Aaron Williams. I'm an associate in our Cleveland office. Give you a quick update. The Supreme Court is still deciding which cases it's going to take and which cases it's not going to take this year. And so wanted to give all of you a quick update as to where those cases stood. So the first one is the Google v. Oracle case, which is actually a holdover from the 2020 term. The court heard oral argument in the fall of last year, and we are currently awaiting a decision. We're going to talk about Google v. Oracle here shortly. The next case is Jack Daniel's Property Incorporated versus VIP Products LLC. The Supreme Court denied Jack Daniel's certiorari petition, which asked the court to decide two issues involving trademark protection. The first issue was whether a commercial product using humor is subject to the same likelihood of confusion analysis applicable to other products under the Lanham Act, or must receive heightened First Amendment protection from trademark infringement claims where the brand owner must prove that the defendant's use of the mark is either not artistically relevant or explicitly misleads consumers. And then the second issue was whether a commercial product's use of humor renders the product non-commercial under 1125C3C, thus barring, as a matter of law, a claim of dilution by tarnishment under the Lanham Act. 1125C3C is one of the exclusions for protection under the Act. That case involved a parody called Bad Spaniels, which depicted a Jack Daniel's dog chew toy in what Jack Daniel's deemed a disparaging light. The next case on the court's docket was Moodsters Company versus Walt Disney Company. The court denied the cert petition there, in which the Moodsters Company asked the court to determine two issues involving copyright law. The first issue was whether originality is the proper standard to determine character copyrightability. And the second issue was whether copyrightability for a character or any work is a question of fact or involves questions of fact, making it ill-suited for resolution on a Rule 12 motion. The fourth case is Arthrex Incorporated versus Smith and Nephew Incorporated. There's two or three consolidated actions within that appeal in which the court granted certiorari. Oral argument is scheduled to be heard on March 1st, and we will be talking about that case here shortly. The next case is Minerva Surgical Incorporated versus Hologic Incorporated. The court granted the cert petition there, and we'll be talking about that case in more depth here shortly as well. American Axle and Manufacturing Incorporated versus Nepco Holdings LLC. The Supreme Court has not made a decision whether to grant or deny the cert petition. It recently requested a response by American Axle and signaling that the court it has not made up its mind and is looking for more information to help it do so. We'll talk about the issues presented in that case here in a couple minutes. Lastly, the case of Ivanix Pharmaceuticals LLC versus Gilead Science. The court denied cert in that case, which presented two issues. The first, whether the United States Court of Appeals for the Federal Circuit, whether a genius claim is not enabled as a matter of law if it encompasses a large number of compounds, or whether, as the Supreme Court has recognized, enablement is a context-specific jury question. And the second issue was whether, as the Federal Circuit has held, 35 U.S.C. 112A contains a separate possession requirement, or whether, as the statute provides, Section 112A sets forth a single substantive requirement of a written description of the invention sufficient to enable any person skilled in the art to make and use the same. So those were all of the cases that have been petitioned to the Supreme Court this year, involving primarily intellectual property issues. And so we'll now move into talking about the cases and issues specifically. So the first case we're going to talk about is Google v. Oracle, which, as I said, is a holdover from the 2020 term. And for those of you that attended our presentation 2 weeks ago on Google v. Oracle, I apologize. Some of this will be repetitive of what we covered there. But by way of background, for those that aren't familiar with the case, Oracle had sued Google in 2010, alleging that Google had copied more than 11,000 lines of code from Oracle's proprietary APIs. An API is an application programming interface, and they are pre-written chunks of Java code that allow a coder to write common functions easier. Java is open sourced and free for anyone to use, but Oracle sells access to its APIs. When Google was designing the software platform for its Android phone, Google created its own library of APIs, but in doing so copied portions of Oracle's code, as well as the overall structure, sequence, and organization of its API library. So this is a copyright case, and there are two issues presented. The first is whether the code Google copied is actually copyrightable. In 2012, the district court agreed with Google that the code it copied was functional and therefore not subject to copyright protection because it was not a protectable form of creative expression. Oracle appealed that ruling, and the Federal Circuit reversed and remanded the case, siding with Oracle, indicating that although functional, that should not automatically preclude copyright protection. As the Federal Circuit stated, an original work, even one that serves a function, is entitled to copyright protection as long as the author had multiple ways to express the underlying idea. Google could have structured Android differently and could have chosen different ways to express and implement the functionality that it copied. Back in front of the district court, Google raised the second issue in this case, which was whether or not it was entitled to copy the code under copyright's fair use doctrine. In 2016, the district court again agreed with Google that it had made fair use of Oracle's code. Oracle then appealed that decision to the Federal Circuit, which overturned the district court and stated there was nothing fair about what Google did. It stated, and I quote, "Although Google could have furthered copyright's goals of promoting creative expression and innovation by developing its own code or by licensing Oracle's code for use in developing a new platform, it chose to copy Oracle's creative efforts instead." The Federal Circuit denied Google's fair use arguments, and the fair use doctrine involves four factors. One, the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion taken, and the effect of the use upon the potential market. So the question logically is what's going to happen in this case now that it's reached the Supreme Court? It's really anyone's guess at this point. During oral argument, the justices' questions were split, indicating that this case could really go either way. Justice Roberts, in response to Google's argument that developers must be able to copy and reuse code if there's no other way to write it, said to counsel, "You say that was the only way for you to do it, but you know, cracking the safe may be the only way to get the money you want, but it doesn't mean you can do it." Whereas Justice Breyer, on the other hand, in response to concerns raised by Oracle and Oracle's seeming monopoly over the code, likened the APIs and the source code that was copied to a keyboard, saying you didn't need to have a QWERTY keyboard at the beginning. But my God, if you let someone have a copyright on that now, they would control all typewriters. So it's likely that this opinion is not going to get a majority, a clean majority of the justices. But how it's about and what information we have on copyright's fair use and the copyrightability of software should provide us guidance moving forward.
And I'll take over now and talk about our next case, which is the Arthrex versus Smith and Nephew case. This is the case, for those of you who have been following it or are aware of it, where the Federal Circuit had found that the manner in which the administrative law judges at the Patent Trial and Appeal Board were unconstitutionally appointed. The Federal Circuit went in and also provided a fix to that. And that issue is now up before the Supreme Court. We have two issues before the court. The first is whether, for purposes of the Constitution's Appointments Clause, administrative patent judges of the U.S. Patent and Trademark Office are principal officers who must be appointed by the President with the Senate's advice and consent, or inferior officers whose appointment Congress has permissibly vested in a department head. And the Federal Circuit, again, had ruled that they were principal officers who must be appointed by the President, but they were not. The second issue is, if administrative patent judges are principal officers, did the Court of Appeals properly cure any Appointments Clause defect in the current statutory scheme prospectively by severing the application of 5 U.S.C. Section 7513A to those judges? And without getting all administrative law on us here, that is basically the provision that essentially gives the administrative patent judges civil service protection. The Court of Appeals found that if they could sever that protection from the judges and give the director more unilateral authority to remove those judges, that would cure the constitutional defect that was found. Now, again, this was a case that began because Smith and Nephew filed for an inter partes review of an Arthrex patent that dealt with a knotless suture securing assembly. We won't have to get too far into the actual technical details of that. The PTAB decisions are made by panels of 3 ALJs who are appointed by the Secretary of Commerce in consultation with the Director of the Patent Office, but they are not confirmed by the Senate. The appeal of those panel decisions is taken directly to the Court of Appeals for the Federal Circuit without additional internal review unless rehearing by the board is requested and granted. And that rehearing, as of September 2018, can include a request that the Presidential Opinion Panel, or POP, intervene and review the decision of the board. And the POP includes the director of the PTO, the patent commissioner, and the chief judge, of which 2 of those 3 are, in fact, Senate confirmed. So Smith and Nephew had prevailed before the board. The claims of the Arthrex patent were found unpatentable. So Arthrex appealed that to the Federal Circuit, one of its arguments being that the board, as constituted under the America Invents Act, is unconstitutional because the ALJs were not nominated by the president and confirmed by the Senate. So as we see in this slide, the Federal Circuit decision basically focused on a 3-factor test under the Edmund case: whether the appointed official has the power to review and reverse the officer's decision, the level of supervision and oversight an appointed official has over the officers, and 3, the appointed official's power to remove the officers. And focusing on the first and third factors, the Federal Circuit held that the ALJs were principal officers and thus had not been constitutionally appointed. And again, they purported to remedy that defect by severing the ALJs from the protection of the Civil Service Administrative Law Statute, basically giving the director wider latitude to remove the ALJs. Following this, and again, we have part of our resources we have available for you are the Federal Circuit panel opinion that we just discussed, as well as the rehearing petition, the decision on the rehearing petition, which was denied in March of 2020. That document has a multitude of opinions showing that there was a wide variety of positions on this within the Federal Circuit. The government actually was the first party who petitioned for certiorari. That was on June 25th of last year. Petition was granted on October 13th of 2020. Opening briefs were filed on November 25th. There have been 31 amicus briefs taking various positions. And just last Thursday, February 19th, Arthrex filed its final reply brief. Its argument there basically is that the severability solution that the Federal Circuit came up with was itself insufficient to cure the constitutional defect, arguing that Congress would not have enacted the AIA without adequate protection of tenure for the ALJs, and therefore it should be up to Congress to determine how to remedy the problem and not just rely on what the Federal Circuit did. So now that it's all teed up, there are basically 4 or 5 possible outcomes depending on how you want to analyze it. One possibility is that the court could say that Arthrex did not properly raise the issue before. They did not raise it before the board itself. They only raised it for the first time at the Federal Circuit. The Federal Circuit held that that was okay because if you were arguing that the tribunal you were before was unconstitutionally set up, you should not have to have raised that issue with that board. So the Federal Circuit allowed Arthrex to raise the issue for the first time on appeal. There's a possibility the Supreme Court may take the opposite view, in which case they would reinstate Smith and Nephew's win. Second possibility is the court will rule that the Federal Circuit was just wrong on the merits, that the ALJs are inferior officers and they were constitutionally appointed, in which case the whole thing is a nothing burger. They'll reverse the Federal Circuit and reinstate the win for Smith and Nephew. Another possibility, the court could rule that the Federal Circuit was correct, the ALJs were principal officers, and that what the Federal Circuit did by severing their tenure protection was an appropriate remedy. In that case, they would just remand the case to the board for further proceedings. Another twist on this is that the court could rule that the ALJs are principal officers, but that the board's establishment of the Presidential Opinion Panel, the POP, is sufficient to have cured the problem because it does allow for a more robust review of the panel decisions, so they could rule that a fix has been appropriately put in place and remand for further proceedings. Or the fourth possibility, the court rules that the ALJs are principal officers and the Federal Circuit fix is insufficient and they don't decide on one themselves, but just say this whole thing has to be fixed by Congress and we're not going to fix it, but in the meantime, the board is unconstitutionally set up, and the result there would be, in a word, chaos. And we'll just have to see what happens if that would be the case. But again, the oral argument here is just coming up this Monday. I'll be paying attention to what happens there, and if any of you are interested and want to shoot me an email, I'll be happy to share with you my thoughts once we see how the oral argument goes. Aaron?
Thanks, Bill. The next case we're going to talk about is Minerva Surgical v. Hologic. For those of you that aren't familiar with the case, It involves a medical device inventor who sold the company he created to commercialize his invention, along with the rights to multiple patents that the company used and commercialized. That entity was Hologic. That inventor, after selling his company, then started a new medical device company, Minerva Surgical, to directly compete with his old company. Hologic sued Minerva on at least 2 patents that the inventor had assigned during the sale. During the litigation, Minerva sought to challenge those patents on invalidity grounds, and the district court held that the doctrine of assigner estoppel applied, thereby preventing Minerva from asserting invalidity defenses. For those of you who aren't familiar with the doctrine, assigner estoppel applies where either the assignee of the patent or someone in privity with the assignor attempts to invalidate the patents that were assigned. The trial resulted in a jury award in favor of Hologic in an amount of $4.8 million in damages for lost profits. The Federal Circuit sided with the district court's application of the doctrine of assigner estoppel, and Minerva Surgical appealed to the Supreme Court. The issue on appeal is whether a defendant in a patent infringement action who assigned the patent or is in privity with an assigner of the patent may have a defense of invalidity heard on the merits. As I mentioned, the doctrine of assigner estoppel is a product of longstanding product of equity, and it prevents an inventor from assigning a patent and then later challenging its validity in court. Minerva actually filed its first brief with the Supreme Court on Monday, giving us a little bit of insight into its arguments regarding the doctrine of assigner estoppel. Its brief has asked the Supreme Court to abolish the doctrine, which it referred to as uncommonly lawless. In support of that position, Minerva stated that there's no textual support in the Patent Act for the doctrine, which has caused courts to erroneously read the doctrine into law. Specifically, the Patent Act provides no exception to the rule that accused infringers have patent invalidity as a defense to infringement. Minerva also argued that the doctrine is judge-made and rooted in principles of private state law-based contractual equities. There are 2 wrinkles to this case that weren't presented in Minerva's issue statement on cert. Particularly in its brief, it asks the Supreme Court, if it's unwilling to do away with the doctrine completely, to at least make 2 carve-outs, which are invariably related to Minerva's defense at trial. The first carve-out it asked for was that the doctrine should not bar an inventor-assigner from challenging the validity of claims that issue after the patent is assigned, particularly in Minerva's opinion, because doing so frustrates competition. The background to this request is that after the inventor had sold and assigned his patent rights, Hologic got additional claims on those patents issued by the U.S. Patent and Trademark Office. And those patents had been at issue in the underlying litigation, but were dropped on the eve of trial. The second wrinkle that they've asked the court for is they've asked the court to allow accused infringers to raise written description and enablement invalidity defenses, even in spite of the doctrine. As Minerva frames it, not allowing accused infringers to do so would embolden inventors to seek overly broad claims, knowing that they will not have to defend against validity challenges in court. The other interesting aspect of this case is that the doctrine of assigner estoppel does not apply in inter partes review proceedings. In particular, the Federal Circuit has held that the doctrine does not apply in IPR proceedings. This case actually involved cross petitions for certiorari. Hologic had actually filed its own petition asking the Supreme Court to rule that the doctrine of assigner estoppel does apply in IPR proceedings. In particular, the issue they flagged was whether an assigner of a patent may circumvent the doctrine of assigner estoppel by challenging the validity of the assigned patent in administrative proceedings before the Patent Office, and then using the Patent Office's finding of invalidity to collaterally estop the assignee from relying on the patent in infringement litigation in district court. The Supreme Court denied cert on Hologic's petition, which at a minimum signals that the doctrine still does not apply to IPR proceedings. It's tempting to read into the court's decision to grant cert for Minerva and deny cert for Hologic as signaling what the court will do with the doctrine. But there may be a variety of issues that led the court to deny one and grant the other. So while there might be some indication that the court is likely to find the doctrine inapplicable or do away with it or carve it out somehow, we just won't know, particularly until oral arguments are held where we can get a better gauge as to what the court is thinking on the respective arguments of the parties. And so with that, I will turn it over to Bill to discuss American Axle.
Thanks, Aaron. So American Axle and Manufacturing versus NEPCO. This is a case that has not yet been, petition has not yet been accepted. My own thinking is that it likely will, at least to the first of the issues that NEPCO had presented for review. The first issue being what standard determines whether a patent claim is directed to a patent ineligible concept under Step 1 of the Supreme Court's two-step approach to determining patent eligibility. And those of you who have been following this area will recognize that this invokes the Supreme Court's Alice test from the 2013 Alice case, which discusses patent eligibility under Section 101 of the Patent Act. And pursuant to the Alice inquiry, the court is to inquire whether the claim is directed to non-eligible subject matter, such as a law of nature or a mathematical algorithm. And if the claim invokes such non-patentable subject matter, Part 2 of the test is to determine whether the claim as a whole amounts to more than the non-patentable subject matter, i.e., is the claim transformed by virtue of an inventive concept. And since this test came out about 8 years ago, it has caused all sorts of angst and uncertainty at trial courts before the Federal Circuit. Basically, people have taken to predicting how an Alice issue is going to be resolved by the Federal Circuit based on the composition of the panel, which is not always a great place for the state of law to be. In this particular case, and the reason I think this one may be accepted, the patent in question was directed to a method of manufacturing automobile drive shafts. We do have a copy of the Federal Circuit opinion that's available under our resources tab if anyone wants to look at this in more detail. But basically, there was one of the ways that they were making these drive shafts was tuning a liner of the drive shaft to attenuate vibration. So Claim 1 of the patent said that one of the steps in the method of manufacturing was tuning at least one liner to attenuate at least two types of vibration. And the Federal Circuit held that that claim was okay. Claim 22, which was a separate independent claim, included the step of tuning a mass and a stiffness of at least one liner. And the Federal Circuit held that that claim was directed to non-patentable subject matter because tuning mass and stiffness was related to a mathematical formula known as Hooke's law. So even though these were not an independent and a dependent claim, on its face, it seemed that the Federal Circuit was holding that a more general claim seemed to be directed to patentable subject matter as opposed to a more specific claim. So that seems a bit odd, and I think it may pique the Supreme Court's interest on this. The second issue that's been presented for review is whether patent eligibility is a question of law for the court based on the scope of the claims, or a question of fact for the jury based on the state of the art at the time of the patent. I'm not sure whether or not the Supreme Court will accept this second question, because I think if they accept the first and do any type of a change to the standard on this, it will probably leave the other part of the question open. If it does accept it on the second question, I would imagine it will leave it as a court question. But we will just have to see what happens on there. I actually don't know if I have the latest timing on when we expect to hear on this one. In fact, I'm not sure. I'm not sure if they've asked for the response yet, but I do expect that there's a good likelihood the Supreme Court may take this one for review. Aaron?
Thanks, Bill. We're going to get away from the case law a little bit here and talk about some issues to watch coming up this year. The first issue is the Trademark Modernization Act, which was enacted as part of one of the coronavirus relief bills on December 27th, 2020. It's set to be fully implemented, by December 27th of 2021. And it has a two-prong approach to addressing both litigation and prosecution of trademarks. Sorry, looking at the slides here. So the three pieces of information to kind of know from the Act is that, first, it resolved a circuit split regarding an evidentiary burden to obtain injunctive relief. That's the litigation aspect of the Act. The other two changes it made were to prosecution of trademarks. One, it changed the procedures for applying and responding during the trademark application process. And it also provided new mechanisms for parties to cancel or to clean up the trademark registrar. So first, we're going to talk a little bit about the litigation aspect. So the legislation was enacted to correct a circuit split primarily originating out of the Ninth Circuit, which was caused by the Supreme Court's 2006 ruling in eBay Incorporated versus Merck Exchange LLC, in which the Supreme Court held that a patent owner was not entitled to a presumption of irreparable harm by showing patent infringement. That ruling was then taken and applied in the trademark context, and some courts found they could no longer presume irreparable harm from a mere showing of trademark infringement. Courts, in looking at whether or not to grant temporary restraining orders, preliminary or permanent injunctions, often required a trademark holder to show a loss of control of business reputation or customer goodwill in order to obtain any form of injunctive relief, whether temporary, preliminary, or permanent, and often would discount or not even consider evidence of customer confusion as being a basis for irreparable harm because customer confusion went to the underlying question of infringement. So Congress enacted language that is being added to 1116 of Chapter 15 of the United States Code, in which provides a clear rebuttable presumption. Language is on your screen, but it says, a plaintiff seeking any such injunction shall be entitled to a rebuttable presumption of irreparable harm upon the finding of a violation identified in this subsection in the case of a motion for a permanent injunction or upon a finding of likelihood of success on the merits for a violation identified in the subsection in the case of a motion for a preliminary injunction or temporary restraining order. As some of you know who practice in this area, injunctive relief is often the one thing trademark plaintiffs want, yet it can oftentimes be the most difficult and costly remedy to obtain. The evidentiary burden and cost of obtaining the relevant evidence to show a loss of control of business reputation, customer goodwill, things along those lines, which require survey evidence and other economic analyses, are costly, are difficult to perform, and take time. The statute helps to give the trademark holder a leg up in obtaining injunctive relief. It makes these types of cases more palatable for plaintiffs to bring in the first place, particularly where they are not seeking damages, and in some ways provides a cost savings to trademark plaintiffs, at least at the outset of the case. The other side effect is that by creating this rebuttable presumption and ending the circuit split, it ends forum shopping that has occurred particularly since the Ninth Circuit adopted the eBay case in the trademark context. In particular, one statistic I read found that trademark cases fell in Ninth Circuit district courts by over 30%, directly or indirectly, following the Ninth Circuit's position on irreparable harm. So plaintiffs were either not filing their trademark actions or were filing in any other circuit that they could reasonably find to avoid this evidentiary burden. Moving to the prosecution side of trademarks, the Trademark Modernization Act has put in place some new procedures that you should be aware of with respect to obtaining trademarks. The Trademark Modernization Act now allows an applicant to request anywhere between 60 days to 6 months to file its response. Additionally, the Act codified the USPTO's longstanding practice of allowing letters of protest, which allow third-party evidentiary submissions prior to registration regarding a trademark's registrability. The downside of the codification is now that there's a fee to submit it. It's $50, and the USPTO must act on those submissions within 2 months. And any decision on those letters of protests are final and non-reviewable. The Trademark Modernization Act also allowed for new cancellation procedures for parties looking to clean up dockets or file for marks in new areas where someone may have already registered a mark. The first procedure is expungement, which allows any person to request removal of some or all of the goods or services in a registration. The basis for this request is fairly narrow, and the requester must show that the registrant never used the trademark in commerce with those goods or services it's asking for expungement on. Our ex parte expungement must be brought within 3 to 10 years after the registration date. So there is a timing window that you need to be aware of. The next is an ex parte reexamination procedure, which is substantially similar to the expungement, in which any person may request removal of some or all of the goods or services in a registration. This basis, again, is limited and narrow and applies only to those goods or services a registrant failed to use in commerce on or before a particular date. And these claims must be brought within 5 years after the registration. So under either of these new ex parte reexamination procedures, the director will determine if the submission sets out a prima facie case. If it does, the petition will be granted and a proceeding will be instituted in which the mark owner will then have the opportunity to present evidence of use or excusable non-use. Decisions in these ex parte proceedings are appealable to the Trademark Trial and Appeal Board and thereafter to the Federal Circuit. The third new procedure is a new ground of cancellation, which is substantially the same as the ex parte expungement proceeding, but it can be brought anytime following 3 years from the mark's registration. The Trademark Modernization Act has created a fairly comprehensive list of options in this area. You have re-examination, which is available in the first 5 years following registration. You have expungement, which is available 3 to 10 years after the registration date. And then you have a new ground of cancellation, which can be raised anytime following 3 years after the mark's registration. So depending on the timing in which you're looking to cancel or expunge a particular basis for a mark, one or more of these options will be available to you moving forward. Bill?
Thanks, Aaron. And I will, did that one? All right, it's all popping up at once, which is fine. But before moving on to this next case on copyright fair use, wanted to mention a couple of things. First of all, and sorry we didn't mention this at the outset, if any of you have any questions, there is a Q&A tab, should be a Q&A tab along the bottom of your screen. So if you pop that window up, you can ask a question, and Aaron or I will do our best to try to answer it either now or later on offline. Before I move on to that case, there is one other aspect of the new Trademark Modernization Act that I wanted to mention because it also could play into the resolution of the Arthrex case on the patent side, and that is that in the Trademark Modernization Act, there is a provision that allows the director of the trademark office to unilaterally review and overturn any decision of the Trademark Trial and Appeal Board. That was put in here potentially as a way to head off a challenge before the Trademark Board, similar to the challenge of the Patent Board in Arthrex. So it leaves open the possibility that the Supreme Court could look at this and say, yeah, this is unconstitutional, and we think one thing you could do is go back to Congress and have them add a provision such as is in the Trademark Modernization Act to the PTAB Act, which would allow the director to unilaterally reverse or review any PTAB decisions. We'll have to see, but that's also a live possibility. But next, I'm going to talk about a couple of copyright fair use question cases that are pending. These are not before the Supreme Court yet. But they follow on from the Georgia versus publicresource.org case, which we discussed in the 2020 review session that Aaron was a part of a couple of weeks ago. For those of you who were here, for those who were not, just briefly, that was the case in which the Supreme Court held that the annotated laws of the state of Georgia could not be copyrighted. And this was not just the text of the law, but also the annotations that had been approved by the court and published, I believe it was by LexisNexis. They were held all to have the force of law, and therefore you could not be held liable for copying those materials. And that dealt with quote unquote laws that were literally expressed in these documents. The cases that are following on from that are one step removed, but we'll have to see if those go in the same direction. The first of those is pending in the District of Columbia District Court, the American Society for Testing and Materials, which is ASTM, also versus publicresource.org. ASTM and other standards setting organizations provides standards for the testing of materials, products, composites, what have you, and often those standards are incorporated into various state or municipality building codes and other official publications. So the question then becomes, do those standards in fact have the force of law such that one should be able to copy those and needs to be able to refer to those? I'm involved in a case that's tangentially related to these cases, so I can't editorialize too much. But in this ASTM case, there was an earlier grant of summary judgment in the plaintiff's favor, basically saying, yeah, there's no fair use here, public resource. ASTM does have a copyright in their standards, and you can't copy them. That was appealed to the D.C. Circuit Court of Appeals. There was a permanent injunction that was vacated. The thrust of the court's opinion, and we have that opinion available in the resources tab, the thrust of that opinion was that fair use applied such that other parties should be able to copy and disseminate these materials because they do effectively have the force of law. Interestingly, there was a very brief concurrence by Judge Katsas, who basically said, yeah, I'm fine to go along with fair use, but let's leave open the question of whether this stuff can even be copyrighted under the Constitution, under the copyright law. So that's very much a live issue going forward as well. So that case, the ASTM case, has now been remanded to the D.C. District Court. Summary judgment motions have been rebriefed, and they are pending. The second case, the International Code Council versus UpCodes, and that is pending in the Southern District of New York. It was filed in 2017. In that case, International Code Council, or ICC, publishes building codes. Those building codes, again, get adopted and incorporated by reference by various states and localities. So the question then remains, is presented again, can those be copyrightable? If they are copyrightable, is it fair use to be able to access and disseminate copies of those works since they have the force of law? So we have cross motions for summary judgment there were both denied. And this case is now sitting in the Southern District of New York awaiting a trial calendar date, which, as we all know from the last year, is something that may or may not be coming anytime soon. The most recent entry I saw on this indicated that they were maybe aiming for the fall of 2021, but we'll have to see. There are probably cases ahead of it and how soon they get going with jury trials up in New York. But it's at the very earliest at the end of this year before we see a trial on that. On the ASTM case in the D.C. Circuit here in the District Court, that could we could get opinions on that, I guess, at any time. I'll turn it back to Aaron.
Thanks, Bill. The next issue to kind of keep an eye on and that we're going to talk about is patent venue. And particularly, we're going to talk about the In-Rate Google case, which was talked about slightly during our last webinar in 2020 review. But the Federal Circuit has been fairly active in issuing decisions involving the patent venue statute. In addition to the In-Rate Google opinion of February of 2020, it issued in another mandamus action filed by Google, pretty much a short ruling in which it told Google to come back to the Federal Circuit after it had actually litigated the case so that the Federal Circuit could determine the issue further. And then in November 2020, issued another patent venue ruling in Valiant versus Milan, in which the court ruled that the Hatch-Waxman Act patent suits can be brought only in locations that are related to the generics maker's filing of an abbreviated new drug application, not in a venue in which the generic product may one day be sold. The court focused that in these cases, they're about past acts of infringement not future acts of infringement, and therefore, under the statute, can only be brought where the actions leading up to the filing of the application occurred. So by way of background, in the Google case, Google filed a mandamus to the Federal Circuit in early 2020, asking it to consider the Eastern District of Texas's decision to find venue proper there. The background facts of this case involve Google contracting with an internet service provider within the Eastern District of Texas, where Google was sued for patent infringement, to host several of Google's cache servers. Those servers functioned as local caches for Google's data within the ISP, or the ISP's data center. They were installed in the ISP server racks, and each ISP provided Google with rack space, power, network interfaces, and IP addresses, as well as network access between Google's cache servers and the ISP network subscribers. Google's use of the ISP data center was plaintiff's hook to sue Google in the Eastern District of Texas. As some of you may be familiar, 28 USC 1400B is the patent venue statute, and states that venue is proper for a case alleging patent infringement in any judicial district where the defendant resides or where the defendant has committed acts of infringement and has a regular and established place of business. For these purposes, the Supreme Court has ruled in TC Heartland that a domestic corporation resides only in its state of incorporation. Google was not incorporated in Texas, so the plaintiff had to show, one, that Google had committed acts of infringement in the Eastern District of Texas, and two, that Google had a regular and established place of business in the Eastern District of Texas. The Federal Circuit ruled that a server shelf owned and controlled by a third party could constitute a regular and established place of business under the patent venue statute. The Federal Circuit highlighted that to constitute a regular and established place of business only requires a specific, i.e. fixed location within the district from which the defendant carries out its business. While this case involves server racks and ISPs, it has potentially broad ramifications for those of you in that ship products to consumers, have distribution networks throughout the United States, and use shipping and fulfillment centers to carry out your business. The impact of the court's decision, excuse me, is that the focus is not on whether or not you, the defendant, own the real property or lease the real property. Rather, it's whether or not there is a fixed location that a plaintiff can point to from which you operate your business. Excuse me. So, is there a fixed location? The Federal Circuit ruled that the server shelf in the Google case was a fixed location. Any place where you can point to it, a physical address, can be fixed. And so that the opinion in Google broadened the scope of what could be a regular and established place of business. What limits it, though, is whether or not you have an employee or agent conducting your business from that fixed location. So Google argued, and the Federal Circuit agreed, that a place of business requires the presence of a company employee or agent who conducts the company's business from that place. The Federal Circuit in the Google case looked quite extensively at the contracts and agreements between Google and the ISP server. But the general principle that we can take from this is that the court stated that an agent's activities cannot be merely connected to the defendant's business, i.e. general maintenance of the servers, but rather should constitute a part of that defendant's business in the sense of production, storage, transport, and exchange of goods or services. So this is where distribution facilities, your network of getting your products to the consumers could potentially open you to suit for patent infringement in a venue that you were unsuspecting. So it's important to keep a sense of where and how your distribution networks, particularly for goods, are and whether or not it would be inconvenient if you were to be sued in one of those jurisdictions. So Bill, I think you're going to take us home with the Philly Fanatic. Bill, you're on mute.
And I just realized that I had my mic on mute, so that's no good. This was a case filed by the Phillies in New York against Harrison Erickson. That was the company that designed the Philly Fanatic back in 1978. And the reason that they have a copyright dispute now, you wouldn't imagine that there would be a copyright dispute about something that has been around for so long. However, there is a fairly little-known provision of the Copyright Act, Section 203, which talks about grants of copyrights. And they put this provision in when the Copyright Act was amended. The new act was passed in 1976, talking about any grant of copyright. Termination of the grant may be effected at any time during a period of 5 years, beginning at the end of 35 years from the date of execution of the grant, or if the grant covers the right of publication of the work, the period begins at the end of 35 years from the date of publication of the work under the grant, or at the end of 40 years from the date of execution of the grant, whichever term ends earlier. So basically what that did, starting in 1978, when the Copyright Act went into effect, was any agreements whereby a party thought it was buying all the rights to a given creation, there is a silent ticking 35-year countdown that gives the original owners of the work, or the creators of the work, the right to terminate the grant and basically reopen the negotiations. And that is what the Harrison Erickson firm did here with the Phillies. That agreement had been executed in 1984. So the 35 years began in 2019. Harrison Erickson sent a termination notice to the Phillies in 2019 that gave them 1 year and said in June of 2020, we are going to terminate your right to use the Philly Fanatic. So the Phillies sued for a declaratory judgment to try to clear up the rights on this. And we have the entirety of Section 203 available in the materials. It is typical of some of these copyright statutes. It's a bit ponderous, but the key provisions are this one, but also subsection B, which basically says that even though the grant is terminated as to the original work, the grantee can continue to use any derivative work that was prepared under authority of the grant before its termination. So that led to this result, which was the design of this, which is, according to the Phillies, a revised version or a derivative work of the Philly Fanatic. The things that are most stand out are the eyeballs are different. It now has stars instead of circles as eyebrows. It has kind of a different tuft of blue hair above the eyebrows. You can't quite tell from this angle, but the schnoz is a bit different. And whereas the old Philly Fanatic had the body go down right to above the shoes, now we actually see legs, for whatever that's worth. So The question that's going to fall for the court here is whether this new version of the fanatic constitutes a derivative work or whether it was just a workaround for them trying to avoid the problem. The Phillies have filed a motion for summary judgment. That was just in December. That's not been ruled on yet, and I would think the court will rule that there are factual issues precluding summary judgment, but time will tell, and we just thought that would be a fun one to end on as we just are hitting our time.
Well, Bill, we don't have any questions from the audience, and it being 1 o'clock here, I just want to say thank you to all of our attendees for joining us during or leading up to your lunch hour. And if you have any questions, feel free to reach out to Bill or myself. Our contact information is in the presentation, which you all should have access to through the resource tab. Thank you again, and I hope to talk to you all soon.
Thanks, everybody. Thanks, everybody.